Today we're going to talk about the essentials of estate planning, and so I'm going to try very hard not to be a nerd. Okay, so if we get to that point where it gets too confusing, somebody can just shout out nerd, and I'll just kind of pass along, and we'll go on that way. You have the outline of what's going to be on the PowerPoint up here, and I encourage you to write notes. It's got space for notes. I know the print is very small, so you may want to write other things in. So my understanding is that everybody has an outline, correct? And everyone has a pen, right? So in order to encourage you to start writing, I'm going to give you my name and telephone number. Okay, and write it at the top. You will not get a business card from me. My name is Burke, B-U-R-K-E. Last name is H-I-N-D-S. And my cell phone number is 612-309-5340. Excellent. So that's how you write on the sheet of paper. And I will give you some things that you will want to write down as you go through this during the day. Now we're going to talk about estate planning, and estate planning can be very complex, or it can be pretty simple. But we're not only going to partially talk about estate planning today. What we're really going to talk about is stuff. Has anybody here seen the George Carlin sketch on stuff? I see one. There's somebody laughing. You've seen it? It's hysterical. He talks about all the stuff that we accumulate during life. He says when you start off in life and you're young and you're just starting on your life, you have a little bit of stuff. And it doesn't take much room, and you got maybe a one-room efficiency apartment when you're going to college or starting your first job or when you're first getting married. And then you accumulate more stuff. So as you accumulate more stuff, it fills up and fills up and fills up, and finally you need a bigger place for your stuff. Stuff can be things that are not only tangible, but things that are intangible, and it can be people too. You accumulate stuff, your kids are your stuff, your grandkids are your stuff, your family members, even charities can be stuff. And then George Carlin says, but there comes a point in time when you have to figure out what stuff you're going to take on vacation. Because you can't take all your stuff. You got to take the important stuff. And so what are you going to do? You're going to get out the suitcase and you're going to say, okay, what stuff do I need? So what we're going to really talk about today may be estate planning, but we're really going to talk about what stuff do you really need. And I hope it's a little entertaining. It's kind of a dry subject because the lawyers have messed up estate planning and made it all really complicated. And a lot of it is because of the terminology. There are certain things that have two names that can be used interchangeably. There are certain things that have words that you think they know. There are certain words that get used that may be used in other states but aren't used in Minnesota. There may be a completely different name and it refers to the same person. For example, most of you have heard the term executor. The term executor does not exist in Minnesota law. It's called a personal representative. They did that just to confuse you. So part of the process for today is hopefully to unconfuse you to a certain extent about estate planning and have you come with an idea. Now, why do you want to write down things onto this little outline, and why do you want to keep it? And the answer is, it saves you money, or potentially can save you money. Because there's confusion about estate planning, when you go in and sit down with a lawyer to talk about your personal estate planning, one of the problems is the lawyer has to spend a bunch of time to educate you. It's great that Summit puts on these seminars because what they're doing is educating you in advance. So when you write down things that apply to you or information that you may have been confused about on that sheet, and my understanding is that they're taping this today and this may be available on the website, this or another one, and you can go back and review it before you see the lawyer. Because the less time the lawyer has to spend explaining stuff, we're back to stuff again, explaining stuff, and the more time that they can talk about your circumstances, it's more efficient for you, it's more efficient for the attorney, and it could end up in saving you money and certainly saving you time and aggravation. So that's why you want to write on your little sheet here today. So here's the dry agenda. We're going to talk about estate planning objectives. We're going to talk about wills and probate, that much misunderstood probate. We'll talk a little bit about trusts. We will talk about alternative decision makers. And now it's time to get started. So let's start with the estate planning basics. The whole idea is to plan and to manage your assets. You do that with your investment advisors at Summit with respect to your financial assets, and they do a really good job helping you manage other things like the estate planning. So the idea then for estate planning is to conserve your assets during your lifetime, and then to dispose of the assets where you want it to go, and that you've made that clear so that whoever's taking care of it after death will know exactly what you want to have happen. There can be, the question is, who's going to handle your affairs? We will talk about executors, personal representative, trustees, agents under a power of attorney, conservatorships, all those confusing words, and I've already made it too confusing just by listing those things off. Hopefully by the time you leave, it'll be a little bit more understandable what those things are. There are special situations that can affect you. I mean, one plan doesn't fit for everybody. If you're divorced, you got divorced kids, you're single, you're married, same-sex situations. We now have individuals who are marrying that are of the same gender. So all of those kinds of things are changing. You might have a disabled child, or you may have an incapacity of a spouse. There are all kinds of circumstances that can make the plan. So every plan is not the same. Your circumstances are all different. They may be similar enough to one another to be able to utilize the same sort of documents, but picking out what you're going to put in your plan can be very specific. Some people want to include charities. Other people don't want to include charities. That makes a difference in the plan. So finding the right advisor, whether it's a financial advisor, a lawyer, or a CPA, is very important, and you probably know that from income taxes and handling that situation. So what are the reasons for having an estate plan? Well, the biggest reason is making sure your stuff goes where you want it to go and how you want it to go there. And also picking the people who will be responsible for your stuff when you either can't be or have passed on and are no longer available and it's to go to somebody else. Just like filling out the sheets on the piece of paper, the more informed you are about the process, also can reduce legal complications and expenses when an estate needs to be settled. And I'm guessing that many of you have probably dealt with your parents' estates and had to go through that process, and you know that it can be complicated, you know that it can be time-consuming, and the easier that you can make that by either doing things yourself or understanding the process and requiring less education time is very helpful. The last thing that's mentioned here is tax considerations. And as it's turned out, tax considerations for estate and gift tax purposes apply to a lot fewer people than it used to, as we'll talk about in a couple of minutes when we get to that. Income taxes, however, are always important. So let's talk about federal taxes first. There are estate taxes. However, and there are a couple things I want you to write down. For federal purposes, the exemption in 2013 for each one of you, the amount of money and assets that you can give away without any estate taxes was $5.25 million. So if you have two spouses, the amount you can give away is $10.5 million. Now many of you maybe remember at that point in time, back about 15, 20 years ago, when there was a $600,000 exemption for each spouse. Well, the number of returns that was actually filed, I think in 2011 or 2011, I believe, was 14,000 returns for the entire country. 14,000 federal returns was all. Those are the people that were above basically the 10 million, the 5 million and 10 million exemption. That's not very many people for the number that die in a particular year. So federal estate taxes are not going to apply to very many of you, if any at all. Income taxes, however, always apply. For example, when you have an IRA or a pension or profit sharing account, and you distribute that to a spouse, remember, unless it's a Roth IRA, you've never paid income taxes on that, but you've earned the money so that the income taxes are deferred. Now, when you take money out of your IRA or your profit sharing plan, you get taxed for income tax purposes, right? If you die and pass that asset on to your children or to your spouse, when they take money out of that IRA or profit sharing account, they will pay income taxes on it. So we're, strangely enough, actually to the point where the income tax planning can be more important than the estate tax planning. And we'll talk about that a little bit. The tax rates for federal purposes are upwards of 40%. It may not apply to everybody depending upon the rate brackets you're in. And for Minnesota purposes, it goes up into the 9% range. So we're talking about, close to 50% income tax rates on all of that. Certainly.
Does that apply to appreciated stocks?
For estate tax purposes, when you die, you get a stepped up basis to fair market value. So if you bought IBM stock for $1,000 and you held it for a long time and it's worth $10,000, upon your death, if you sold it during your lifetime for $10,000, you'd have $9,000 of capital gain, right? If you die and have $10,000 worth of stock, your basis will increase to $10,000. And if you sold it immediately after death for $10,000, there would be zero income taxes. If you gift the asset during your lifetime, so if you gave that same stock to your kids and transferred it to them, they take the same basis that you had for gift tax purposes. So if you gave it to them and they sold it, then they would have a $9,000 capital gain. So there's really a question about what assets you want to keep in your estate and what assets you might want to gift during your lifetime is, in very many cases, more an income tax question than it is an estate tax question. It's getting a little ahead of ourselves, but for state purposes, Minnesota is one of about the half of the states that has an estate tax. The Minnesota exemption is not $5.25 million per person, it's $1 million per person. So the question is, how important is that? Well, the Minnesota estate tax rate upon death above $1 million starts at 6.4%. If you've got $10 million, the rate goes up to 16%. But the question is, do you want to save Minnesota estate taxes or do you want to save income taxes? If you've got a capital gain, for example, that you're paying 20% on plus the Minnesota tax rate, you're more worried about planning for the income taxes than you are a 6, 7, or an 8% estate tax. But Minnesota does have an estate tax. So when you're planning, what we typically tell people is you have no estate tax issue at all if your assets are under $1 million. If your assets are under $2 million, you might still have a Minnesota estate tax issue. Here's the reason why. Husband owns $1 million, dies, gives it to the kids, or puts it in a trust, which we'll talk about for the spouse and kids. Wife has $1 million and gifts it to the kids. $1 million exemption for each of them zeroes out and there's no tax. On the other hand, if husband dies first, gives $1 million to wife now has $2 million. Upon her death, her estate is going to pay an estate tax on anything above $1 million. So you're going to pay a tax on the extra $1 million. So that's kind of the planning that we used to do for federal purposes, but we used to be talking about 35, 40, 45, 50, and even 60% tax rates for federal purposes. And the question is, how important is that 6 or 7% Minnesota estate tax? And that's one of the specific circumstances that you're going to want to discuss with your advisor on your situation. I will add, under state taxes, here's something you're going to may want to add in. Minnesota is one of 2 states that has a gift tax. This went into effect last July 1st in the round of tax increases that Minnesota went through to balance their budget and create additional money, apparently. There is also a $1 million exemption for gift tax purposes during your lifetime for each person. And anything above that has a 10% rate. Now, you have to have a lot of money, obviously, to be giving away $1 million or $2 million during your lifetime, but just be aware that Minnesota does have that. Now we'll talk about federal gift taxes. Each of you can give $14,000 to any individual per year worth of stuff without using any of your $5.5 million, $5.25 million exemption. It's the freebie. I used to call it the Volkswagen Bug exemption, gift tax exemption or exclusion. Because back when I was young, it was about $3,000 to buy a Volkswagen Bug, and that's when the annual gift tax exclusion was $3,000. And so basically, it's kind of increased by inflation to whatever the least expensive car you can possibly find new for your kids. That's kind of what the exemption is. But you can do that. So I had one client many years ago that had 26, and the exemption was $10,000. So they had 26 children, spouses, grandchildren, spouses, great-grandchildren. And that means each year, husband can give away $260,000, wife can give away $260,000. That's over $500,000 per year they gave away for free, and they didn't use any of their exemption. This is a company that you would know. It was a closely held company, and they actually gave away the entire company over a course of 3 years. So that $14,000 is very valuable. However, let's go back to the question about the IBM stock. Do you want to give the IBM stock with a basis of $1,000 to your kids and a fair market value of $10,000 and let them pay a $9,000 capital gain? Or do you want to hold it until death and give it to them upon death? And I suppose it kind of depends upon how much your kids are complaining that they're not getting any money from their rich mom and dad. And so there's certain things that kind of transcend income tax planning. The $5.25 million lifetime gift and estate tax exemption is indexed for inflation. So in fact, this is 2013 and 2014, it's now $5,340,000. So you double that up for the spouses. There are a few exceptions that may not apply to people. One is that you cannot, there are exceptions to the gift tax. You can also give your spouse an unlimited amount. I used to say if you were Bill and Melinda Gates and Bill had all the Microsoft stock and it was worth, what is it, $7 billion or something like that, he could give all $7 billion to Melinda, pay no federal estate tax, but watch out when Melinda dies. Okay? You can gift whatever assets to your spouse, either outright or in a trust. The only exception is if you have a non-citizen spouse. There are limitations. The concern is that non-citizen spouse will leave, go back to whatever the home country is, and it'll never be taxed. And so there are special rules that have to be followed. There are also exemptions for gift taxes. Obviously, you don't pay estate or gift taxes to give to a charity. That's an exemption. There are other exceptions. For example, if you're paying for college for a child or a grandchild, you can give that amount for tuition above the $14,000 as long as you pay it directly to the institution. So if you pay the tuition directly, similar rule for medical expenses. If you pay medical expenses on behalf of somebody, that doesn't count against the $14,000. All right, so that kind of sets up the background. So mostly tax planning isn't a big issue. When tax planning becomes important, then I will tell you the planning process becomes much more complicated and also more expensive. So going back to the basics again, what kind of techniques, planning tools do we have for handling your estate planning issues? Well, the first is a will, and we will talk about wills specifically in a minute. There are trusts, and I will explain what those are and how they work. You can make gifts. There's life insurance and IRAs, retirement plan accounts, annuities, things that are transferred by beneficiary designation, and then joint ownership of property. Now at this point, I do want you to write something down. There are two kinds of joint ownership. The first I'll call survivorship joint ownership. That means whoever lives longest wins. So typically spouses will own their home as joint with rights of survivorship. So whichever spouse lives the longer after the first death, you go to the county courthouse and you give them an affidavit of survivorship that says, I survived, I win, transfer the title of the property from husband and wife's name just into wife's name, for example. Okay? It's a sheet of paper, it goes automatically. Now you can own property jointly with rights of survivorship, not just with a spouse, but with anybody. So you could have a piece of property or an account, a bank account, that is owned jointly with rights of survivorship with a child, for example. So if that child survives, then the child gets the account. So assume that you are a single individual, spouse has died or you're never married, and you decide, and you've got 3 kids. But you've got one really responsible kid, the one that's helping you pay your bills, the one that's taking care of you, that comes to visit or has dinner every Sunday night, you know, those kind of things, brings the grandkids over, that sort of thing. So you say, I'm going to go down to the bank and I'm going to change this account so that I own it jointly with my daughter, for example. Well, if that's the case, and you've got $100,000 in that account, and you presume that your assets are going to be divided equally among your kids, you're just doing it for convenience. When I die, there'll be funeral bills that have to be paid. I want my daughter to be able to pay it. And all of a sudden you realize, maybe you don't because you've died, that your daughter ends up with that $100,000 and only the other assets are split. So you need to be really careful about setting up those kinds of accounts. If you're going to do that, you're going to name all 3 kids. So now what happens if one of those kids dies? Then what happens to that child's share? Does it mean it just goes to the 2 that are surviving? So dealing with joint ownership of property is a touchy thing. And as a general rule, other than between spouses, I'm not a big fan of that. Because accounts go away, they come in, they change in value and that kind of thing, and it can mess up your plan. And you don't want to be going back to the lawyers and changing that all the time. The other kind of joint ownership is called, I'll call it a TIC, T-I-C. And it's called a tenancy in common. Now, tenancy in common might apply, for example, if you have the family cabin that you own with your brother, and you each own a 50% undivided interest in the cabin, that's different than rights of survivorship. If you survive, it doesn't mean you win. It's a little bit like a partnership where whatever percentage you own, which could be 50%, 25%, whatever the number is in that property, whatever percent you own, you can transfer that along like any other asset to your heirs. So your 50% interest in the cabin, if it's owned in tenants as common, means your share is separate from your brother's share. And people get confused as to how they hold property. Does anybody have that situation where you own property with somebody else? Yeah, okay. Naming beneficiaries. Naming beneficiaries, you want to be very careful. Just like the bank accounts, typically you'll name your spouse, then your kids. You may actually want to name your estate. But that's going to apply to IRAs, 401ks, pensions, life insurance, and I would add annuities to that as well. And the question is, those assets transfer upon death based upon the beneficiary designation, not based upon your will. You know, the other thing is that when you have IRA, profit sharing, retirement plan kinds of accounts with an employer or something like that, be prepared for that potentially to be frustrating. Because they have a form online, or they give you a form. If you want to do something different than checking the boxes that they have, they may reject it, they may give you, it takes a whole bunch of time to try and get it processed and that sort of thing. Remember I told you that IRA, retirement plan beneficiary, or retirement plan transfers that whoever receives the money ends up having to pay income tax even though you've died. That's why making charitable gifts out of IRAs and profit sharing is a really good idea. Naming beneficiaries, it's all based upon your circumstances. Do you want to give it to your parents? Are they going to use it? Are they too old? Will it be subject to estate taxes for them, for Minnesota or for federal purposes? Are they too young? Are you giving it to minors? How are you setting it up? So paying attention to what the beneficiary designations are, I will just say, is very specific to you. It changes for different individuals, and you need to be very careful about it. I do want to look at the per capita or per stirpes, and that is my retirement plan account goes to my spouse. If my spouse doesn't survive me, in other words, if I survive, then it goes to my kids. But does it go to the kids that are living at the time? So for example, if I had 3 children, and each of them had children, if one of my children died, does that child share go to the surviving 2 kids, or does it go to the grandkids along that line? That's what per capita is, or per stirpes. Does it go down the line? And so beneficiary designations can be very complicated.
Which one is which though, per capita or
Per capita is by head, okay? Per stirpes, which we don't call it per stirpes in Minnesota, it's called right of representation, which makes more sense because the assets are going down the line based upon, as representative of the child in each generation. So per stirpes means down the generations. There are different rules for different situations, and you really need to reevaluate those things. Doing a will is not enough. Okay, wills. Yes? Oh, stirpes is a Latin word. Yep. Okay. The question is a per stirpes question about whether or not spouses are included in that. So the example was beneficiary designation to sister. Sister dies, and the designation says per stirpes. Does that go to her husband, her sister's husband, or does it go to her nieces and nephews? And the answer is it goes to nieces and nephews. It goes by bloodline. And so it's a great point. Considering spouses, for example, my mom's estate plan says that if I predecease her, my share goes to my wife rather than to my daughter, because if I were to live and I were to receive that from my mom, I would want it to go to my wife rather than my daughter, and my wife can take care of our daughter and that sort of thing. So that's a great point. Wills. If you own a piece of real estate and you wanted to transfer it, you wanted to sell it, if I'm going to sell it to Linda, okay? How do I transfer that property? It's in the name of Burke Hines, owns my home, and I'm going to sell it to Linda. How do I do that? I'm going to sign a deed of something that's in my name to transfer it to Linda, and I'm going to get it notarized, and then we'll file it with the court, right? If I've died, however, if that house is residing in my name, but I can't sign the deed, who's going to sign the deed? The executor, the personal representative. So the question becomes, what passes under a will? And what passes under a will is stuff you own in your name alone that is not transferred by beneficiary designation and isn't owned jointly, with rights of survivorship. So if you're married and your house and your bank account and your investment accounts, and if you've designated your spouse as beneficiary of all the retirement plan assets, what in the world do you have to transfer under a will? And the answer is nothing transfers under the will, right? The only thing that they might transfer that way is personal property, but the spouse basically has the right to that anyway. All right? So you don't even need a will, really, right? Now, when the spouse dies, the surviving spouse dies, then you want a will because now you want to tell what happens. And you never know which one's going to happen first. And so you need a will ultimately for the second death, because even though everything was owned jointly at the beginning, by the time you're done, it's all owned by one person.
What about stepchildren?
Stepchildren, you're going to have to add in separately. They're not considered your children. An adopted child is, but a stepchild is not. So now you're going to have to define children as including those stepchildren if you want to do that. Yes?
You're saying you each need a will,
Yes,
because you never know which.
because you never know who's going to die and who's going to survive. Exactly. All right? If you have a will, it's much easier to transfer in the way you want to. Probate is the process where a will is determined by a court, maybe very informally, that this is how the property is to pass. It was signed by you and all the requirements were made, and therefore it's the controlling document, and it names a personal representative or executor to transfer those assets. What is probate for? It's to pay your bills and to transfer the stuff. Transfer the stuff the way you've done it. Okay? People think probate is extraordinarily complex. It's not always that complex. And it isn't always that expensive, and it isn't always time consuming. It may take 6 months, 9 months, something like that, especially if you're selling a house, that sort of thing. But probate doesn't have to be particularly onerous, and you can do it on an informal basis unless there's a dispute among the kids or other circumstances, or if you have other real estate to sell. Depends upon your assets, but probate isn't anything really be scared of. Okay? They talk about cost and time issues. Well, I will tell you that if you have a lot of stuff and a complex plan, it's going to be time consuming and expensive. If you don't have much stuff and it's not very complicated, then it's going to be less so. That's basically what it comes down to, whether or not you have a will or not. By the way, doesn't look, naming guardians is a big issue, particularly if you're divorced is a big issue also. For a reason for having a will. Yes?
How did probate get to have such a bad reputation? It's not such a scary thing. I've always heard, oh, you don't want to go probate.
In some states it is scary. Part of it is that executors take percentage fees and get way overcompensated. That's not allowed in Minnesota. It's all done on an hourly basis. And if there's a dispute, then it goes to court and the judge determines what a reasonable fee is and that sort of thing. It's typically the time and expense. If you need to do something immediately, sometimes it's difficult. You know, if you're selling the house and you need somebody to sign right away after a death or something like that, then it can get more complicated. But it got a bad reputation because probates are normally where fights happen. Lawyers, advisors were overreaching and that sort of thing, but it's largely a historical thing. It's not anything to be concerned of. Yes?
When it goes to probate, doesn't that then become public information?
Yes.
So,
Yes. When something goes through probate, everything's filed with the court. When you go through probate, what do? You file an inventory. Dear court, here's my list of all the assets that I own, and that's public record that anybody can see. Here's how it's to be distributed. Here's a copy of the will that anybody can see, which is why on the internet you find Jackie Onassis' estate plan and that sort of thing. I had a client in northern Minnesota that was a business owner, a fairly wealthy family, not exorbitantly so, but one of the brothers was a judge and really didn't want it to be public. And so we'll talk about avoiding probate. So privacy, you know, in the Twin Cities, unless somebody really cares that much, you know, it may not make a lot of difference, but if privacy is a really important thing for you, you're probably going to want to use a revocable trust, which we'll talk about. The executor, which we call the personal representative, is responsible for settling the estate. So now we get to the next one. What happens? Yes?
The executor, is it realistic to say use your child?
Yes, absolutely. As a matter of fact, I will often pick the child. I'm not picking it, but the clients will pick the child that happens to live in the area where you live, because if you've got one in Seattle and one in Tennessee and one here, you've got a house that has to be practically cleaned out, estate sale, you know, get the transfer, hire, you know, a real estate agent and that sort of thing. Then somebody needs to be here to do that stuff. Any of the children could act as the personal representative, but typically it's the one that's most responsible, most organized, closest, but you might have all three kids because the child that's here was really good at cleaning out and taking care of the sale of the house, but not so good financially and isn't very organized. So let's have the one in Seattle also be a co-personal representative, and then they just split up the duties because they're going to basically inventory the stuff and do tax returns because it's a separate, an estate is a separate entity. So, but that's a good point. So how do you avoid probate? Well, as I said before, well, you can use trusts, which I'm going to talk about. You can make gifts ahead of time, but then you've got that IBM basis issue. You can use joint ownership. We're talking about like the land owned or a bank account owned with a child, making sure that you split it up correctly. You can do transfer on death. You can do that for securities accounts, bank accounts, so that the child doesn't have any access during lifetime, but you could say, this bank account goes equally to my children, a designation that you do with the bank or the investment custodian that says it goes equally to my kids. That has their own issues, but that will avoid probate because it's like a beneficiary designation. It doesn't go through your will because it's not in your name, and if there's another way to designate who's receiving the property other than having to do my deed to Linda, right? So if it's in your name and there's a beneficiary designation, that doesn't go through probate. Joint property doesn't go through probate. Transfer on death doesn't go on probate, through probate. Payable on death accounts, those are bank accounts that are transfer on death. And retirement plan, life insurance beneficiaries, for example. You can, however, designate your estate, your proper estate, which is basically, and have it all be controlled by your will. And sometimes we do that for tax planning purposes. Well, actually, you talk about avoiding probate. Sometimes I tell people you don't want to avoid probate. You want all the stuff coming together so when you divide it out, particularly if you're giving 20% to one kid and 40% to another child and 40% to charity, then you want the whole pot in one place, and sometimes that's your estate. Executors, we've talked about. You can cross that out. That's called personal representative in Minnesota. And they settle the affairs. Their duties, like I said, were filing tax returns, filing inventories, and you should let the person know who you've selected that you want to administer your estate. There are people that you can hire. Kids oftentimes won't take any fee for it. There are banks and trust companies that will act as professional executors, particularly if you have kids that you know are going to fight and there's going to be an issue and you really want to protect it, or you got a ne'er-do-well in the family or something like that. You may want a professional to do that. You can probably expect a 1% or 2% fee plus any additional services, tax returns, and that sort of thing. So it can be a fairly spendy thing. So if you got $1 million, you're going to get a fee of $20,000 a year to manage the estate, and if it takes a while, that adds up to a lot of money. But yes, there are professional, but you can do either an individual or a corporate personal representative. All right, yes?
If you did one of those professionals in a different state that allows the executor to take, I believe in Illinois, it was up to 10% of the estate the executor could take. Would that professional executor then be entitled to that?
Well, in the past when I've used them, it's always been negotiated. You go around to several of them and you negotiate. They have fee schedules. I mean, 10% would be an extraordinary amount other than for a complicated, I mean, here in Minnesota, they've got fees, but even the judges, you know, if somebody contested it, which anybody can do who is a beneficiary. So the question is, do percentage fees in another state? In other states, if you own property, does anybody own a place in Arizona, a place in Florida, a cabin in Wisconsin, that sort of thing? Okay, those, any real estate someplace else that you own also will complicate your planning significantly because each state has their own rules. So, getting close. Trusts. First of all, I want to tell you what a trust is. I assume everybody knows what a corporation is. Corporation owns stuff, financial assets, businesses, that kind of thing. Corporation has a president and a treasurer to manage it. And they manage it for the shareholders, right? A trust is an entity like a corporation except that, and it owns stuff, it takes title to stuff so that the ownership is in the name of the trust. It has no CEO, no president or treasurer, but it has trustees. And the trustees are the ones that manage on behalf of not the shareholders, but the beneficiaries. And those are the people for whom the stuff is being held and managed. That's what a trust is. Now, during lifetime, and I think this is the next one, is to protect assets. If you own, let's go back to my home that I wanted to sell to Linda. If that title is in the name of Burke Hines, then upon my death it has to go through probate, right? On the other hand, if I say I don't want to go through probate or I'm concerned about privacy, issues like that, I'll say I'm going to set up the Burke Hines Revocable Trust. Revocable, revocable, living trust, they're all the same title for the same thing. And what does that trust say? That trust says, Burke, while you are alive, you can be your own trustee, you manage it, it works like a will upon your death, but it owns the property for my benefit during my lifetime. Now, who's the trustee of that trust? I am. Or maybe my wife and I are the trustee of that trust. Now, when I die, that real estate is no longer in the name of Burke Hines, so it doesn't go through probate. It's owned in the Burke Hines Revocable Trust under the agreement dated March 6th or whatever it is, 2014, if I did it today. And the trustee is Burke Hines and Amy Hines, my wife. So I die, Amy is the trustee. She can sign the deed as trustee to give it to Linda, to sell it to Linda. All right? Doesn't go through probate. Not public, no administration, not included on the inventory, nobody's going to see it. And why would you want a revocable trust? And that is, if I went out, on my 2-block drive back to my office, I got hit and was disabled and had a brain injury, I can't manage my stuff, right? I want Amy to manage my stuff. If I was disabled and I couldn't manage my stuff and it was in my name, Amy would have to go to court and be named as a conservator, which is like an executor of an estate that goes on for forever, that is subject to court supervision, because you don't want people ripping off disabled folks and people who can't manage their own affairs. So those are really arduous and they are expensive and they are a real pain. I'd rather have Amy taking care of it. So instead, what I would do potentially is to do a revocable trust, transfer my assets, other than maybe our joint bank account, our joint accounts and that sort of thing. Transfer my assets, transfer the home, transfer investment accounts and that sort of thing into my revocable trust, so that if I become disabled or had a stroke later in life, or who knows what might happen, then she can manage it for me as long as I'm alive. Okay? So that's a revocable trust. I forgot to flip. Revocable trust, yes, can be changed. Oh, the other thing is on death, anytime I can amend that trust, or I can get rid of it and take the assets back and put it in my name. So it's just like a will. You can change a will anytime and as many times as you want. I actually had a client that literally was a member of the Will of the Month Club. She did 12 wills in 12 months. It was a sad situation, and it was not handled properly. All she did was change the charities depending upon which charity she liked that week and who called her. So she was quite infirm, yes. Yes?
Back in the disabled part,
Yes.
you're sort of marginally disabled, not enough to do the right trustee duty,
Yes.
but not enough that you're not going to be certified as
Yep.
disabled. You're kind of stuck in the middle.
The question is, if you're talking about a trustee or a beneficiary, somebody. Okay, so if you're a trustee managing an account, somebody, names their brother who's elderly, and the brother has an event of some sort, typically the documents will provide for somebody to be allowed to remove that individual, the kids, a spouse, whoever that is. Otherwise, it's, but obviously, anytime you talk about capacity issues, one of the questions is, how far out of it do I have to be to not be able to do a will? And it's very simple. Capacity to sign estate planning documents requires basically two things. One is you need to know who the natural objects of your bounty are, who your family are, and you need to know what stuff you've got. So if you know you got a house, you got some investment accounts and that sort of thing, so that the standard for doing an estate plan is very low, but you're also subject to influence by individuals, one kid over another, and so the fights occur on capacity, not when mom or dad is incapacitated and can't really handle the situation. As long as the kids are in agreement, then there's no problem. If the kids are fighting, then it becomes a problem. So the same thing can happen with the trustee, obviously. Yes?
I've got a question. You said before that, if you pass away, would all the assets be taxable at that time? If you're not on the trade?
The question is, when you pass away, are all of the assets subject to taxation at the time when it get passed on to the kids? The answer to that is yes, but it depends upon what the value of the assets are. For estate tax purposes, if it's less than $1 million, it's irrelevant, and for, you know, like I said before.
Instead of doing that, you put it in a trust fund, and you have them as trustees, and have it distributed in set amounts.
Okay.
Not taxed on it all at once.
Uh,
And everything is,
Yeah, the question is, if you put the assets into a trust, is it subject to tax? Now, let's be clear. There are two kinds of tax. There's an estate, they're related, estate and gift tax, and then the income tax, all right? So for estate tax purposes, if you put it into a trust during your lifetime, and it's something that you can change, you still own it, okay? And then if you make distributions out of that trust to your children, that's a gift, okay? If you put it into an irrevocable trust, so I take $200,000 and put it into a trust, I've just made a $200,000 gift at that point, and transferring those dollars then to your kids and dribbling it out over time and naming your brother, for example, as a trustee to manage the assets for your kids. As you distribute it out for gift tax purposes, you're not making another gift because you made the gift when you put the $200,000 in. Okay? For income tax purposes, the $200,000 that's sitting in the trust will earn income, right? Or at least we hope so. Then that income is either going to be, if you just retain it in the trust, will be taxed to the trust, or if you distribute the income, say $20,000 a year to a child, the child pays the income tax. So it kind of passes through. Oh, nobody yelled nerd. I was expecting to hear nerd.
you transfer a Roth, if you die,
No. Oh.
to the Roth for the estate.
Why don't we talk about that afterwards, if we can? Okay. So we did touch on irrevocable trust. That's the $200,000 into a trust. You have no power, you actually give it away into a trust that tells how it's going to be distributed. And either the trust or the trust income, the trust will pay the income tax, or the beneficiaries will. That's basically a tax planning thing that doesn't apply to most people. Living trusts. I want you to write next to that revocable, because typically I call this a revocable trust. And we talked about the assets moving to heirs without going through probate. The next slide is types of trusts. And quite frankly, unless you're doing tax planning, the only trust you really need to be concerned about is a revocable trust, which is one that you control but is there for the purpose of handling your stuff if you become incapacitated. And then upon death would be just like a will. Alternate decision makers. And when I see we have about 7 minutes left, alternate decision makers is really important. Alternate decision makers include powers of attorney, and there's a lot of discussion about that. And there's a lot of concern also about who you name as what's known as the agent. This is somebody that can act on your behalf. And typically for an estate plan, you want to name somebody who can do acts on your behalf if you are unable to do so. So if I get hit in the car and disabled on the way back to the office, and I own this piece of real estate in my name of Burke Hines, and we want to sell it to Linda so that we can get an apartment, or I'm in a care facility or something like that. If I give Amy, my wife, Amy, a power of attorney so that she can act as my agent, she can basically file an original power of attorney with a court or a certified copy, and she can sign for me, and she would sign it, E. Burke Hines by Amy J. Hines, agent under power of attorney dated blank. So even though I still can't sign the deed to Linda, Amy can sign it for me. Now I want to be very clear about this. When you prepare, in Minnesota, when you prepare a power of attorney, it is effective the moment you sign it. Okay, so if you give a child or a family member or a friend power over your stuff, as a general rule, they can do anything with your stuff that they want. And there are a lot of cases about people that have been ripped off by children who have stolen their money using a power of attorney because they get control of the bank account, the investment accounts, sell the house. My partner had a case just like that, where a guy kind of went around, befriended people who didn't have anybody else, became the power holder, the agent, and ripped them off. So it's something you need to be clear and understand that there is a risk to that. On the other hand, there's also a risk of not having it. So who holds those original powers of attorney to use them is an important thing. And you can name co-agents as well, where they both have to sign off. In most cases, it's not a huge risk, but boy, when it goes bad, it goes really badly. Power of attorney gives another person legal authority on your behalf, can take effect upon implementation or when a specified event occurs. Those are called springing powers of attorney. In other words, in some states, they allow a power of attorney when I become disabled. But then the question becomes, how do you know when I'm disabled? How do you certify that? So Minnesota's power would become immediately effective, and New York, for example, has a springing power of attorney, and I'm not sure how it gets certified, but I suppose you probably have to be certified incompetent or something like that. So Minnesota doesn't have that. And the power of attorney terminates at death. I've had a number of people say, well, mom died, I have a power of attorney, can I sell the house? And the answer is no. Because you remember, you're acting as an agent for somebody. If they're not alive, you can't act on their behalf. Healthcare directives. Healthcare directives do actually two things. One is, and these are sometimes known as living wills, and they are generally referred to as the pull the plug provision. Now that's pretty ingracious, and it doesn't apply and it doesn't tell you anything. It just says, I don't want, extraordinary measures if I'm otherwise not going to survive, or I'm in a persistent vegetative state, or all the cases that you hear about. So the first is to make your wishes known as to what you want to have happen. And those are fairly detailed, and the ones that I use have kind of gone through some doctors, and they say that's okay. What it really does, more importantly, is it names a health care agent. So if you're in a car accident, you've had a stroke, you're unable to communicate with your doctors, remember this HIPAA thing that you sign every time you go to the doctor, where I can't talk to anybody about your health. It grants somebody to be your agent for healthcare purposes. They can get your medical records, they can talk to the doctors, and you've got a sheet of paper that says, I hereby allow my agent to make decisions for me when I cannot make them myself. So it gives them the power to have the consultations, to know the information, and to make the decisions. All right, typically that's going to be kids. The cases that we see are disputes among siblings or something like that, or among parents and that sort of thing. Parents and spouses. So naming who that person. But the most important thing is giving somebody access to the doctors, to the records, and the ability to make decisions. And having the conversation with them as to what you really want. And it varies. My grandmother, when she was in her 90s, she went into a senior facility, and they required her to have make a DNR decision. If for some reason you fell, your heart stopped, your breathing stopped, something like that, is there a directive to start that again or not to start it again? And it had to be on a refrigerator, that kind of thing. Really important. Her decision was, I've had a number of minor and not so minor strokes. If my heart stopped, you know, that sort of thing, my breathing stopped, then my quality of life would be so terrible at this point. So she had a DNR, do not resuscitate.
Is that what you're talking about?
Pardon me?
Pulsed?
Pulsed?
Yeah, I think that's what you're talking about, what it's called. I went through that with my mother and
Yeah.
the idea that you think that you have that thing on the refrigerator saying, don't do anything. The EMTs in Minnesota are required by law
Yeah.
to get them started again unless
Oh.
you have a pulse, which you have to get from a doctor.
Okay. I didn't know that.
I know,
I will find out about it. Conservatorships we talked about. If you don't have a power of attorney, this is a legal arrangement where one adult manages another's affairs. You know, mom who's had the stroke or has dementia or something like that. And it is usually a spouse, child, family member. There are professional conservators, only permitted in the cases of incapacity, and they're subject to court supervision. And you're limited as to how you can invest it. I mean, they're nasty things. You really want to avoid a conservatorship if you can. So, how to get started? Step number 1, call your summit advisor. Because you're going to need the information that they're going to provide in terms of your assets. Step number 2, get your documents together. Step number 3 is fill out a questionnaire with all the information about all the decisions you've already made. Who do I want to be my agent under my power of attorney? Who do I want on my health care directive? Gives all your names, social security numbers, so when you go to the lawyer, you hand it to the lawyer and say, I may have some things I want to talk about or help me work through some of these things, but here's my full name, date of birth, social security number, all that kind of information, telephone number, how do I contact you, where do you want documents sent? And so there's a questionnaire that's out by the desk here. Is that right, Nate?
Yeah, we'll talk about that here in a second.
Okay, that you can pick up at the end if you want to. The other thing is to sit down and decide how you want your assets distributed. And the one thing that people don't think about is what I call the atomic bomb provision. You may have lots of kids, you may have lots of grandkids and that sort of thing. But the question of saying is, if you all went on a trip to Jamaica, we're in a small plane and the entire family went down, who gets it? Does it go to a charity? I had one client who had, wife had one sibling and husband had 7. So, does wife's family get half? One person get half? Husband's family get half and they divide it all up? Or do they divide it up into the 8 shares and do it on a per capita basis? And then the next question is, if one of those siblings dies, does it go to their kids or their spouses? So when you think about what I call the atom bomb clauses, if everybody in your family died that's in your documents, then where would you want it to go? Do you want to add a charity? Now the prospects are usually very slim that would happen, but ultimately the documents have to say something. They can't just, otherwise it will go to heirs at law, which means it would only go to the husband's heirs for the husband's assets, and nothing goes to the wife's family. So think about how you would want to split that up. Seek an estate planning attorney. And I guess I'm open for questions. -2 minutes ago.